Welcome back to Face the Nation. We're discussing free trade agreements, economic development in Sri Lanka and the controversy that continues to surround the existing free trade agreements and the free trade agreements that are in the pipeline. My first question in this round is to Kitmina Hevage, Research Officer, Institute of Policy Studies. Now, in the earlier round, there was a bit of debate about Mode 4 and Mode 3. Now, the question, the concern that Mr. Vitharana as well as Dr. Rana Singh raised was the fact that is Sri Lanka's best interests being ensured, specifically with regard to that issue. What my question to you is, Kitmina, what's the flip side? What's the situation like in Singapore?
So, I mean, Singapore has also made commitments similar to what we have. I think it's very important to kind of, again, distinguish the differences, right? So, just because a company is established, so for example, just because Shangri-La is in Colombo, doesn't mean that the entire catering staff comes from Singapore. I think that's the difference. The general manager of the branch manager of Shangri-La Colombo might be from Singapore because those are executives, managers and specialists. But the laborers are from Colombo because that's not allowed under the FTA. However, ironically, the big issue of, placement and supply services personnel, the CPC 872 category, is liberalized even more by Singapore rather than by Sri Lanka. So Singapore has liberalized the entire 872 category, whereas Sri Lanka has liberalized only 4. So that's 201, 203, 204 and 205.
Okay, but has Sri Lanka also then ensured the enabling mechanism for Sri Lankans to then go to Singapore? That's the question we need to ask.
So I think that's part of the agreement. So the agreement creates that framework where Sri Lankan entrepreneurs, Sri Lankan investors who have been wanting to get into the East Asian market has an access to that market through this agreement. So it's a matter of, do we have the investors who want to engage and invest in that? And I believe to be yes. I think there are quite a few, if you consult the chambers, they've shown interest in investing in Singapore, particularly when it comes to these services, because that's something that Sri Lanka has a competitive advantage over most of the other developing countries, and they have the unique skills necessary. So I think the framework is created through the agreement. So it's a matter of how do we match those commitments and how do we go through that framework and enable our investors. So it's not the government forcing companies to investing in Singapore if they want to tackle those markets.
Kitmina, does the purported lack of transparency in signing FTAs concern you?
I think we need to kind of be realistic about how agreements work. So like Professor Samaraji already noted, relative to other agreements that Sri Lanka have signed, relatively speaking, this agreement or the consultation process has been a lot more public than before. But yes, things could improve a lot more. I think, as some of my colleagues here have said, some of them haven't been consulted. Some of them have been consulted, but their opinions haven't necessarily been included. I think that's part of the process. I mean, you have to compromise and ensure what's best for the country as a whole. I think the issue of transparency is not necessarily a question that needs to be put in that regard, but rather an issue of how much consultation happens. Because when it comes to negotiations, we need to be realistic about how much information we give to our counterparts. How much do we want Singapore to know about what our interests are in negotiating? So you can't make everything public. You have to have some sort of kind of secrecy when it comes to information. However, it's important to have those consultation processes, and I think Sri Lanka has been facing growing pains when it comes to the consultation process, and I think it's clear that Sri Lanka is moving in the right direction when it comes to ensuring that all parties that are concerned with the agreement. So for example, when it comes to medical services, they're not included in the agreement. So it's not necessary to consult them. in the negotiation process or the consultative process. So when it comes to the services or the industries that are relevant, there is a movement towards consulting them, and we are having these public debates in regards to those. So I mean, that in itself is a major positive movement.
However, you do agree that there's a difference between consultations and effective consultations.
I agree that there is a necessity to move towards more effective consultations. I'm not saying
politically
that
correct as always. Kitmina Hevage, thank you for that response.
Transparency, you have to be open up to the people. May not be necessary to your counterpart, the party state, but you have to open up the people. You have to get the consent of the people. People should participate because it affects the sovereignty of people. And also, as far you can, yes, you can restrict your information as far to the extent it affects the national security. That's the only permissible area that the state can keep to themselves without this. Other than that, you have to be open up.
I think, Mr. Vitara, there are several areas in which, I mean, under the RTI, several grounds have been set out, exceptions.
Even I was there when RTI was argued in the Supreme Court. That was there was argument on both sides, and the Supreme Court said, okay, for the RTI, we'll leave it as it is, keep the secrecy. That is, you can't have information with regard to that. The RTI gives right for a public to have access to the information.
Sure.
So that's the RTI, the scope of the purpose, the objective of the RTI is different. But when it's an obligation, it's a duty on the part of the state to get the participation of the stakeholders, to get their consent. Ultimately, it's going to affect the rights, it's going to affect the livelihood of the people. Rights.
Dr. Rana Singh, I move my attention to you. Now that the free trade agreement with Singapore has been inked, and you, as the past president of the Institute of Engineers of Sri Lanka, you say that you still continue to face concerns, that the issues that you raised have not been resolved. Given the fact that the government of Sri Lanka continues to look to further free trade agreements, how do you propose the government needs to correctly or effectively go about consulting parties such as yourself and other multiple stakeholders in ensuring that it's a sort of holistic process?
Now, basically, although Kitpine said that there is a fair play on the Singapore side also, I completely disagree with this one.
Okay.
Now, this is not purely, I am talking about the profession of engineering. Now, for example, they say in order to work in Singapore, they say at least 51% of the directors shall be registered professional engineers or allied professionals. That means if a Sri Lankan firm goes and work in Singapore, they want to work in Singapore, the entire control will be taken by Singaporeans. It says 51% of the directors shall be registered professional engineers in Singapore. But in Sri Lanka, if they come and work here, as long as under their definition, so-called executives, specialists and managers, if they call managers themselves, they can come and work here. And there is no registration, no qualification, nothing is mentioned about the Singaporeans, those who come and work here. But if we are going to work in Singapore, we are being restricted by these clauses. So therefore, the agreement, what I am telling is actually, when we sign an international agreement between two countries, it should be fair and equal for both parties. Not only engineers, even the other professionals are very concerned about what we have agreed on these agreements, and that is the very reason that doctors are also very active on this issue, because next time it's going to be the practice of medicine in our country. So therefore I would say, although we have been invited for consultations, if the ideas are not taken, it's completely useless. They are merely inviting for consultations won't do. So we have been pointing out these things actually, whatever with the available documents, but the team that has gone for discussions, I would say, has been even trained in Singapore. Their primary training has been obtained from Singapore, and they have overlooked all these important things and just signed an agreement. That is
Dr. Rana Singh, my question to you was, how do you propose that the government needs to consult stakeholders such as yourself effectively to ensure that if any wrong has been done,
yes,
it can be corrected?
In fact, actually, we are open for discussions. We have sent several letters to the Minister and also to the Prime Minister in weaving our thoughts about this agreement. So therefore, always we are prepared.
Has it been to any avail?
No. Only thing is, in public media, what they say, they have consulted engineers, they have consulted the other professionals. Merely saying that they have consulted is of no use. I think rather than now, what most in these discussions, what is happening is actually the team who is representing the ministry, they come and express their views, and they say, okay, you better express your views also, but nothing has been considered. That is not consultation really. What we say is actually, at least when we raise certain issues, it should be considered in signing these agreements, and at least a draft final should be given to us so that we know what are the things that has to be looked into. And that type of attitude has not been adopted by these discussions. So therefore, it is merely we have been spectators of these discussions, although we expressed our views on these matters.
Right, thank you very much. Mr. Kanishka Vitarana, attorney at law, you've been quite vocal with regard to your criticism of the manner in which the most recent free trade agreement between Sri Lanka and Singapore was brought in. Now, this is not the only FTA that Sri Lanka is looking at. There are more in the pipeline. In your opinion, how must the government more effectively go about this process?
As I said earlier, the country should get itself equipped and competent and qualified to enter into agreements. Because
okay. Can you be specific? What do you mean by equipped?
In the future, there may be it will become a must, a necessity.
Sure.
The first thing is we must have a accepted national trade policy. So far, there's no national trade policy. Being a national trade policy, there was even the president in his recommendations wanted a national trade policy. Then there was a new trade policy.
Yeah, I believe there is a trade policy.
No, new trade policy is not what is approved by the cabinet or the parliament to form into a national trade policy. You take the new trade policy. I couldn't bring it here. It's a very short note of a person on economy. Trade policies are goes into bulk, and if the policy in Indian trade, national trade policy is the height of it is much more than this. It should deal with every aspect, how it affects every trade. You take the new trade policy, it doesn't deal with every and each trade, each province, how a trade agreement or the policy wise, it affects what impact or what the role of the economy.
Sure.
Trading, or how the trade would, what impact the trade would have on every aspect, every sector, every community in the country. So this is not it's a camouflage, it's a myth. This is new trade policy, it's not a national trade policy of a country. If you compare with the national trade policies of any other country, this is just a booklet. So for the other thing is, we have to regularize, we have to see, we must have a proper ratification process, which this country doesn't have. We doesn't have a proper ratification process of an agreement. Here we say, this agreement should go through the parliament to get its legal effect, because it deals with taxes, duties. Only the parliament has authority to decide on that. And here in this agreement, it repeals a previous agreement which was resolved by the parliament. An officer cannot, by a free trade agreement like this, nullify a trade agreement which was effected by a resolution of Parliament. So, as far as this agreement is concerned, this is a nullity. There is no force or effect in this agreement, because because especially it violates Article 148 and 157 without going through the Parliament, without getting the approval of the Parliament. This has so many provisions that cannot be made effective. So there's a bottom line. Cabinet of Ministers, that's also there. So that is another factor. So before signing, the Honorable Manik Samaravikrama should have had the approval, the sanction of the Cabinet to sign this. My observation based on the letter of the Secretary of the Cabinet of Ministers dated 17th, I can remember, as far as on 17th, there had been no approval obtained by the minister to sign this agreement with the sanction or the clearance of the Attorney General, because the way the Honorable Manik Samaravikrama stated in the Parliament, he says on the 16th there had been a Cabinet of Ministers. On the 16th the Cabinet of Ministers has approved this, but on 16th of January, if you go through the Cabinet minutes, what is available in the website, it says subject to the sanction of the Attorney General. So we don't know when this Attorney General had given his clearance before.
Kitmina, you have some opposing views.
I mean, I think there's a difference between the signing process and the ratification process. I think what Mr. Vitharana is talking about is the ratification process.
No,
and that's
I was talking on both. First, the signing, the Honorable Minister didn't have the authority. There's no approval of the Cabinet of Ministers. For ratification in process, there's no, in the absence of clear ratification process in this country.
We don't have procedures.
No, under the Constitution, it should comply at least with the provisions of the Constitution. That's what I'm saying.
Wouldn't the Supreme Court decide on that then?
Constitution of the provision, under the Constitution, this should go through Article 148 of the Constitution.
But wouldn't the Supreme Court make that final
So let the Supreme Court decide that there are 7 cases before the Supreme Court on this, challenging the validity of it.
Right. Thank you very much, Mr. Vitharana and Kitmina Hevage. I think, Charita, you have some questions.
I'm being completely neglected.
Yeah.
Don't I get a chance?
There's a question from one of our viewers. Under Mode 3 for executive placement services, how are domestic workers categorized? Are they categorized as executives? And
well, I would like to read the definitions of what these terms are, because one of my colleagues here said that managers can self-describe themselves, right? So I will now subject you to the legal jargon. This is what the definition of a manager is. Persons responsible for primarily directing, controlling or administering an organization, subdivision or a department of an organization, or supervise or control the work of other supervisory, professional or managerial personnel, have the authority to appoint or remove the personnel and powers to exercise a discretionary authority to exercise over day-to-day operations. Such person shall have had a minimum of 5 years of relevant industry or professional experience immediately preceding the date of application. Now the question was about executives. Executives,
how domestic workers are categorized?
They can't be in this category. I mean, there's no service agreement in the world that includes domestic workers. I personally believe we should cover them because they are being exploited everywhere. We are sending domestic workers to Singapore, and I would like some legal protection for them. But that is not the case. We have only opened up these intra-corporate transfers. So let me again emphasize, a Singaporean company must have a branch here. A Singaporean company that doesn't have a branch here, good luck to you. A Singaporean company that has established itself in Sri Lanka but doesn't have a operation in Singapore, not covered. within that only these categories, and these people who have been employed for a period of not less than 12 months preceding the date of the application, before temporary entry. I said that in India it's 6 months. Here it says 12 months, right? So domestic workers cannot in any conceivable way be included in these definitions. I'm sorry, I just don't get it. What this excitement is about. These are specific, big definitions that are legally part of a legal agreement.
But
Dr. Rana Singh,
in our schedule, we are liberalized the more who are the services and coming under the code 87247 204. So 87204 under CPC code included the provisions of maids, nannies, housekeepers and companions.
Who can be who can be employed from Sri Lanka?
Come through the
or Nepal.
As my friend says, it's on through
outside the agreement. Outside the agreement, not within the agreement. I'm sorry, why would you have 4 written there and unbound written there? And
that is you're again misleading. It's under 4.
I'm not misleading. You are outright making false statements.
You are making false statements. You are not talking about mode 3. You are only on 4.
So
I'm on 3.
Mode 3 is allowed only for companies doing that.
Yes.
So companies. So for example, manpower companies who supply domestic workers and so on can come. So it's not the service of labor. Establish themselves. But when it comes to labor, mode 4, it says unbound, which means that it's not liberalizing that. It's as simple as that.
I'll give an example that people will know. Now we have security companies, right? Certis, G4 Securitas, international companies. They can, I'm saying if they were included, I have checked with the security companies are included, but they employ a large number of people. Why on earth would they bring workers from some other country when we have plenty of people here who are cheap, who will work in security firms, ex-forces people, right? If they want to bring people, Gurkhas from Nepal or whatever, right, to provide the really heavy duty security, they'll have to sign labor agreements, they'll have to go to immigration, get the multiple permissions that are required and bring the Gurkhas, not under the agreement, under normal immigration laws. It's as simple as that.
Yeah, no, we are not here talking about security companies. It's a company which is established with the objective of placement and supply services of person.
Yes,
the company.
So the company, the objective. So is the objective of the company is that under that objective, this sector being liberalized.
So that is exactly what I'm using the example of security companies.
No, this
you
is
can
not
have an
security
internationally branded company coming in to provide manpower services, and they employ either Sri Lankans or others who are not covered by the agreement but are brought in under the normal immigration laws. It's as simple as that. If not, we would not have the word unbound. Even unbound wouldn't work, even none would not work. Because everything is subject to horizontal commitments, we'll have to have, in this particular sector, these categories are included. That is the positivist approach. I'm sorry how many times I have said this. But I'm incapable of repeating, explaining this further for people who do not wish to understand.
The other side can't understand, incapable of understanding. Let the spectators.
It is said that that the only person you cannot wake is a person who's faking sleep.
The viewers should understand who's sleeping here.
Kitpina, now in terms of experts and managers, right, what does the provision say? Do they first have to scout them from Sri Lanka? And if such people are not available, does it work like that, or how does that mechanism work?
No. What the provision allows is that they have to have worked for 12 months in Singapore for this company and then come under those specific categories. So managers have to have worked for 5 years, executives for more years, and kind of there are very clear definitions, and then specialists should have kind of specialist knowledge that they source from that specific skill sector. So it's not a case of kind of looking for a lack of supply, if that makes sense. So then I think that's where market mechanisms kick in. So you need to make a decision: would a Singaporean company hire someone, keep them in Singapore for 12 months, at the high level that my colleagues have already said that Singapore already has, which means that they have to be paid more, and then transfer them to Sri Lanka for a cheaper job? No one would come for that, right? So I think that's where the market mechanisms kick in. And here I think it's a matter of the intra-corporate transferees being very specific. There are very definite guidelines as to how that works as well.
Could I just add?
Yes,
Yeah.
sure.
Now, I've gone through this process in the United States. That is, they had to go through the process of saying that my position could not be filled by an American. And that was on the basis of a Department of Labor certification that I was granted my work permit in the United States. That's a completely different argument from here. Here you're bringing a juridical person, a company, and in order for that company to safeguard its brand, or to move tacit knowledge, technological expertise, they bring a certain number of people as defined. Now the executives are defined here as such persons have had a minimum of 5 years of relevant industry experience, wide decision-making powers, either members of the board or directors, receive only general supervision or direction from higher level executives, or the general body of shareholders. So that's a defined category. That is because they embody. Now I'll just, if you don't mind, I'll give an example of how this worked. Telecommunications was covered under the services section of the services agreement, general agreement in trade in services. As a regulator, I used the GATS commitments to try to control the Japanese investor who was here. Now they brought a limited number of Japanese executives for Sri Lanka Telecom. At that point, in 1998, there were only, of all the 3 plus 4, 7 major telecom companies in Sri Lanka, only one, which was 100% foreign owned, had a Sri Lankan CEO. Every other company, including the one where the government held a majority share, had foreign CEOs, right? But what happened over time was that now we have, I think, only one foreign CEO, as far as I can remember. Now all the companies are headed by Sri Lankan CEOs. Why? Because I happened to, as the regulator, I happened to learn how much the Japanese CEO was being paid. And it blew me away. I was considered their system with foreign experts. Because some companies actually lost their business case because they had too many foreign or expatriate executives in the companies. I won't name names, but there was a company that quite didn't take off because they had too many foreign executives and their cost structure was off.
Dr. Rana Singh, you raised concerns about qualifications and expertise earlier, about the registration of qualifications. Given what you've heard thus far from the other 3 panelists as well, is this really a concern for you about intra-corporate transferees with subpar qualifications coming into Sri Lanka?
Now basically, when you are working in another country, who has to assess the qualifications? Whether is it the country which is going to invest, or whether both countries, or whether the country who is getting the investment. Now if a Sri Lankan firm wants to establish a business in Singapore according to this agreement, Sri Lankan company have to satisfy the qualification requirement mentioned by Singapore. They have to be members of the professional organization there. So therefore they have safeguarded their interest and say, no, you can't come and work here. We must ensure that 51% of your directors are qualified members of our professional institutions. Now when a Singapore company comes and works in Sri Lanka, who make this assessment? There is no qualification requirement as stated. Even a specialist, even a so-called specialist, which is supposed to be a person who is having heavy caliber, does not specify a single educational qualification here. He need not be a member of the professional institute, he need not have any qualifications. He has to work as a specialist in an organization in Singapore, and that assessment has been done by Singaporeans. So that is what
Dr.
I
Rana
see.
Singh,
Yes.
I have a question here. Now, Singapore, as compared to Sri Lanka, technologically a far more advanced country. Why would a company coming from Singapore and setting up shop here bring along a substandard professional who would be a burden to that company to come and head up the operation here?
Yeah, thing is
it doesn't
actually,
make business sense.
Now, I will just tell about the construction industry because I have experience in the construction industry. Most of the foreign companies, I don't want to give their names, although they identified some people have engineers, they are just above laborers in their own country. Their passport says some other designation. So therefore, what they do is actually they walk into the shoes of the engineer when they come into Sri Lanka, and they identify themselves as engineers, and they control they have few engineers working under them as local engineers, and get the work done. So therefore, it does not mean actually they want to establish their identity or they want to maintain their quality. They always have to prefer to have a foreigner in charge of their organization in order to look after their interest, whatever it is, irrespective of their qualifications, and they give false designations, and we accept their designations. So this is not happening only in this agreement, that is generally happening here. So therefore, this prevents our people holding high positions in these organizations and running these organizations, and prevent Sri Lankans going and work abroad, invest in another country and holding high positions. So basically what the idea is actually, although they may not be qualified, they identify them as qualified people and they try to work here as qualified people.
Could I add to this a little? These statements are correct with regard to that particular number, that particular sector that Dr. Rana Singh is talking about. But when it comes to other sectors, now take accountancy services, there's no requirement of the kind that he refers to. In the Sri Lankan case, when it comes to construction related services, it says that under mode 3, that is when a company comes in, it says none subject to joint venture with minimum 60% Sri Lankan equity participation, subject to horizontal conditions and subject to registration requirements under the SIDA Act number 33 of 2014 and amendments thereof. So we have also put conditions. Now here 60% of the board of directors would be from Sri Lanka. Now they are now doing something else. So it's just a different way of describing the restrictions they have put in construction related trade. So I think it's not untrue what he said, but it's incomplete.
But there's a confusion with regard to legal services also concerned, because legal services in the schedule refers to another again to a CPC code. What is represented by the CPC code is not an international advisory service, but it is stated so in the schedule. But then, since therefore there's a conflict between what is represented by the code and by the definition given there. So there's a lot of confusion, inconsistency with regard to the schedules are concerned when it comes to professionals. So therefore, that's the reason. Those are the consequences of not having proper consultation process. So that's why anyway this is not approved by the Parliament anyway. So there's no legal effect. So far it is it's removed.
And the gaps are illegal according to my friend here.
No,
It will be decided by court side.
Very
soon it will be decided by the Supreme Court. Very soon it will be decided by the
this will be decided by the Supreme Court. But this agreement, there's a previous Singapore-Sri Lankan agreement also, which is referred to in this agreement. According to this agreement, that previous agreement become to a standard, it would be nullified. That agreement was passed by a resolution of a Parliament. So that's why I say this agreement has done something ultra-virus. The minister has done something ultra-virus, because minister can't deal with the agreement which is already been resolved by the parliament.
Thank you for your thoughts and perspectives. We go in for our final break. We'll be back with the final round. Stay with us. Welcome back to Face the Nation. We're discussing free trade agreements and the way forward for Sri Lanka in terms of economic development, accelerated growth. In this final round, my first question is to Mr. Kanishka Vitharana, attorney at law. Mr. Vitharana, you seem quite dissatisfied with the way free trade agreements are being signed in Sri Lanka. However, we need to end this program on a positive note. We need to look towards the future positively. I mean, it's incumbent upon intellectuals to do that. How, in your opinion, must the government go about better protecting the country's interests when signing, negotiating trade agreements?
Yeah, we must have accepted procedure.
There are accepted procedures.
No. Procedure that should be followed. And the government should be honest to the people. As far as the transparency is concerned, as it is inspired in the course of this discussion, there's lack of transparency in this case. Because now we'll come to the question. We must have a very comprehensive national trade policy, which we have now. It's not a national trade policy which is capable of dealing with this kind of comprehensive trade agreements. Secondly, we must have a ratification process, which is not there at the moment. And thirdly, we must have a consultation process and some sort of accepted procedure that to be followed by every government, in relation to any trade agreement. Then the people can participate. The only thing is the stakeholders should have the right to participate and deal with this agreement prior to at the negotiation stage, prior to the signing of the agreement. Now we have signed the agreement, then we now look back and see, oh my God, now we are not done our part.
So you're saying that effective consultations are usually not had.
We are not had. And also, there's no proper guideline which is forcing, which is compelling the state to follow. So we must first, and also every profession that will be safeguarding the rights of our industries and producers and people. So
we need free trade agreements.
Yeah.
You agree with that?
Free trade agreements, yes, that's what I said. It would be inevitable in the future.
Economic growth, a more dynamic business environment for the country. We need FTAs.
Yeah, otherwise we can't survive as a country in the world. But we must make ourselves competent. We must do our homework and get ourselves equipped with the necessary tools to get into an agreement like this.
Okay. For future reference, what are these tools that you are talking about?
That's what I'm saying. Starting with the free trade policy, the mechanism, ratification process, internal regulatory frameworks in respect of every profession with regard to the standard. That's what Dr. Rana Singh says now. A person would come here and disclose himself as an engineer, some profession, where we don't have a yardstick, we don't have tools here to give clearance as to to evaluate his qualifications here, to register him. But as far as Singapore is concerned, Singapore has every tool as such. You can't walk in and declare yourself as a reporter, a media reporter.
Who should we hold accountable to ensure that these processes are put in place?
State should do it prior to entering into any of these agreements. Singapore has done it, India has done it. Every other country who is very much conversant with these agreements have done it. We have not done it. That's why it's dangerous for us to enter in with India or any other country who has so much of strong regulatory process within.
Thank you. Dr. Rana Singh, as the past president of the Institute of Engineers Sri Lanka, you've been very vocal with regard to the rights of engineers, and you've said several times that the consultations have not been effective and that your recommendations have not been taken into account. Yes. Now, moving forward, now that the agreement has been signed, the free trade agreement with Singapore has been signed, you do need solutions to the issues you face, right? Yes. How are you going to get the government to listen to you? Yeah. What's your plan?
The only thing is, actually, although we have gone represented in the engineering profession, what I say is, actually, we were even discussing about the general things also at these meetings. Now, we highlighted the fact that we have signed an agreement with India where it was only a trade agreement. But the trade deficit between the countries India and Sri Lanka had been continuously growing even after signing the agreement. So therefore we said that first we must study the past agreements and see what corrective measures that has to be adopted in order when we are signing future agreements. Now that has to be done. And also correct people must go for negotiations for these agreements, and with a good combination. I would say people might be qualified, but there should be a combination of proper people, maybe professionals from engineering, professionals from IT industry and various things, so that they know what is really happening in these countries. Now I can give you an example where we have entered into a hedging agreement some time back. So who is the person who went to negotiate hedging? He is a sportsman. And we lost millions and millions of rupees and nobody is answerable. So in this country, if somebody has done a mistake, now he is dead sure that he is not answerable because everybody has forgotten all these things. So we must select the correct people, correct combination, and as Attorney at Law Kanishka said that we have to have we must equip ourselves properly. Now, for example, there was a story about polluting the Kalani River by an industrialist. Now, nothing has happened, just cover up. Now, here, there could be so many factories, if they properly work, so many factories will be open. Do we have a proper system of monitoring the effluents to these rivers and streams? No, we don't have. So therefore, we must have the entire infrastructure properly working, and also the organizations in order to monitor these things. So therefore, it is not in the interest of engineers or doctors, it is a common interest of the country that we have been participating in discussions. But although in spite of various issues that we have brought up, I would say that no fair hearing has been made by the government.
Right, thank you. Thank you, Dr. Rana Singh. Professor Rohan Samarajiva, when it comes to the signing of free trade agreements and the process, the long-drawn process before it, something that we've seen in Sri Lanka is the fact that there's a lot of miscommunication, a lack of proper, correct information being disseminated to the public, as a result of which the whole issue is then politicized, and you know, there are strike actions and protests. We saw this with ETCA. And we are now seeing it with the free trade agreement with Singapore as well. There are, I mean, in Sri Lanka we find youth, professionals, certain sectors of it, of course, being insecure. How should the government go about ensuring that the youth, the professionals of this country, have the professionals in Sri Lanka? It is the responsibility of a government to ensure that the country's interests are best protected initially. What is the government doing wrong, and how should this be corrected?
The first and most important thing is that it's not the responsibility of the government is to the people as a whole. So, for example, nobody has talked about the benefits to consumers, the benefits to other industries of liberalization, of new investment. So if you just go back to something like telecommunications, those days people couldn't run a company, do their business, because telecommunications was so inefficient. It was a critical input. And it was only when that was liberalized, private investment happened, foreigners came in and ran the show, which all the things that we are scared of, that everybody else was able to think about telecommunications as something you take for granted, and they could go about doing their business without running behind people, giving bribes and doing all kinds of things. So the benefit to the consumer must be paramount. Now a consumer benefits when you get rid of protectionism. And there are groups within society, within countries, companies, industries. Now when I was doing for some research, looking at the Information Technology Annex, the ITA agreement, which is part of the WTO, which we have not signed, I found a very strange category, which was for calculating equipment. So this is what these compasses, those triangular things that you do for trigonometry and so on. Huge tariffs had been placed. It is under the information technology category that this old technology, which nobody uses now, was there. And I distinctly remembered when I was a student in school, I had this horrible kavakadu petti. We called it kavakadu petti, one of these things, which didn't do the job. It cut my fingers. I hated it. From a company called Metalix, which I don't know whether it exists now. But they had gone and lobbied the government. This is what protectionism is. They had gone and lobbied the government, put excessively high duties on them to protect their profits, and kept everybody out. Now there are professionals, there are service suppliers who are doing the same thing. They are providing substandard services. Their quality is not good. They say their quality is good, but in actual fact their quality is poor. If the quality of healthcare services in this country are so great, why are people going to Mount Elizabeth Hospital to get their operations done? Why are people who are not so rich going over to Chennai and Hyderabad to get their operations done? Why is it that those companies which provide healthcare services have branch operations here to screen patients? It's because our people, our professionals are not giving quality services in all cases. I'm not making a generalization. There are cases where they could do with more competition. But they are trying to prevent any kind of competition coming. I would say that when Apollo came without any trade agreement, that was a mode 3 entry. I think it improved private healthcare provision in Colombo altogether. They raised the game. And everybody else did refurbishments and so on and so forth. So protectionism is something we have to take into account. To say that the government's job is to protect industries or professionals is not correct. The government's job is to look after the country as a whole, the economy as a whole. And it has been known throughout history that all these special interests are actually conspiring against the general good. So I think that is the most important thing. I just want to say one thing about the fact. Everybody is asking why this. The United National Party went to the people in a tough election where they got the most votes, where they specifically said, we want to close the gap between South Asia and Southeast Asia. They specifically said that in their manifesto. In order to do this, we are going to get GSP Plus, and we are going to sign these particular agreements. They mentioned China, they mentioned India, they mentioned Singapore. So they have got a public mandate. Now to say that a bunch of government doctors and bankrolling this thing is superior to that public mandate, I find it rather unusual expression of what democracy is. When these people went to, they could have played safe and not included it. They included it. They got a mandate. If we say they don't have a mandate, that means we don't think that elections mean anything. That it's simply that you have to continually negotiate with all these special interest groups.
Professor, but there is a controversy here.
They have
I
created
understand
a
your
controversy.
point. However, there are disgruntled youth, there are disgruntled professionals, and they do form a part of this public and the mandate.
Right. There are some people, as I said, those who want to scuttle any of these efforts, who fear, who are for protection. They will, however many times you talk about mode 3 and mode 4, they will refuse to listen because it's not in their interest to understand the concept. These are rather esoteric subjects. They'll go out there and they'll spread fear and get people onto the streets, right? So I'm not in the business of getting people into the streets. I'm in the business of explaining what trade law actually is. And that is what I can do. I'm not a quasi-political party like the GMOA is.
No, my friend refers to GMOA and the standard of health services. Representative from the GMOA should be there here to justify their demand, and also the standard of health services in Sri Lanka is very much high.
But the question is, people have been saying negative things about trade experts. Where are the trade experts here to defend themselves? According to this argument, nobody can say anything negative.
No, Professor.
What is the issue?
With regard to standard,
I gave evidence. There are people who get on aircraft and go to Singapore to get treatment at Mount Elizabeth Hospital. There are people who go to Apollo in India. That's a fact.
With that, you can't reach the conclusion that the standard of the health services is.
Dr. Rana Singh,
that is because for some people government is funding. That is why they are going for Mount Elizabeth, not because bad health service. Otherwise, normal people, 99% of these people depend on the health service of this country. If the politicians are not getting money from the public funds like President's Fund, they won't go to Mount Elizabeth or anywhere.
Well, some people even go to Texas. Texas Medical Center.
So how many people will go? That is less than 0.1%.
That person's bill was also paid by the government, I think.
That is less than 0.1%. 99.9% depends on the local health services of the country, and it has been improved drastically.
I agree.
And in some of these private hospitals, he's talking about investment of this country, they had heart operations and they couldn't close there was a talk that they couldn't close the operation, and therefore they had to go to the public hospitals in order to get these sutures done.
Thank you, Dr. Rana Singh. My final question for tonight is to Kitmina Hevage. Kitmina, my question is two-pronged. I'll ask the first question first. We're going in for FTAs, but we still haven't been able to resolve the, issues we have at ground level. I mean, you take the Middle East problem, where we keep sending our women to the Middle East, unregulated, they come back battered, bruised, maimed, and we don't really have procedures in place. Well, we do, but it's not really effective. But this vicious cycle keeps continuing. But, in complete juxtaposition to all of these realities that we face, that we see on a daily basis, we are now, venturing into all these fancy agreements. Yes, we need economic development and growth and all of that. But don't you see a disconnect here?
I mean, you've asked me the same question that you asked me at the beginning. It's not.
Yes, because I'm not satisfied with your answer.
It's not mutually exclusive, is my very simple answer. I think in terms of what we do to protect our labor that goes out, I think, yes, very clearly we need better regulations, or I think more importantly, it's not the regulations, it's the capacity to regulate. So we need to arm the regulators, for example, the Bureau of Foreign Labor,
Foreign Employment,
sorry. Yeah. They need better capacity. I don't think it's the regulations that are missing, it's the capacity to regulate that is missing. Similarly, when it comes to professional regulations, so my colleagues here, Dr. Rana Singh and Mr. Vitana, have been talking about the lack of professional regulations, and then they put the onus on the state. But the problem is, in most of the countries, the priority of establishing professional regulations are taken by those professional organizations. So, for example, in the EU, it's the Union of Architects that came up with the professional regulations that were incorporated that are being incorporated into all FTAs that the EU is signing. They established it in 1999 and they keep updating it, but that is what gets updated. So the professional associations have to take the onus. So the problem here is that the lack of a framework to regulate the qualifications of professionals right now also means that there are substandard professionals in certain sectors coming from the local system. So addressing that through the framework of establishing these regulations as we need is not just about regulating foreigners coming into this country, but also ensuring that the supply of professionals from the ground is also up to a certain standard. So I think it's a necessity, but that also needs to come hand in hand. It's not the governments don't know what the right qualifications are. It's the professional associations that need to take responsibility and take that leadership. So rather than
but the professional associations are apparently not being listened to.
I mean, apparently professional associations haven't been giving these standards that are required as well, right? I mean, from what we've been hearing. So, I mean, like I said, it needs to go hand in hand between the government taking responsibility.
Kitmina, we are told that the President has ordered a review and that the FTA is before court. Could this be scuttled? If so, what are the ramifications in your opinion?
I mean, if it is scuttled, then it sends a very bad signal to the international community. I mean, it's as simple as that. We have been working, Sri Lanka, it's well known that Sri Lanka needs to move towards an open economy that looks outward. And if we don't do that, we are going to fall into the same debt trap that we've been kind of foreseeing for the future, right? Because government can't keep funding development projects by taking more loans. So it's as simple as that. So given that, the fact that we are trying to establish a better business environment in the country, and this being part of that, this being an important cog of that, means that the failure or the decision to kind of scrap the Singapore FTA will send a bad message, not just to Singapore, but the international community. This agreement and other things, or the Iran agreement, it's sending a message to the international community that they can't adhere to these agreements and that no one can have confidence in what the government is doing. So I think overall, regardless of whether we've had enough consultations or not, I think it's important that we read the clauses clearly. If you look at the sun with sunglasses, you see the sky as being grey, regardless of what the actual sky is. So rather than looking through this, agreement through tinted glasses, I think it's important to look at it from an objective perspective. Read through the economic law as it is, and read through, I mean, there are guidelines all over, and ensure and make sure that this agreement is implemented successfully. And then that be the standard, or improve that standard for future agreements and future reforms, be it unilaterally or through other means, through agreements and so on.
Thank you, Kitmina, for those perspectives. On that note, we wrap up tonight's edition of Face the Nation, but not before thanking our guests this evening. Dr. Ananda Rana Singh, past President, Institute of Engineers, Sri Lanka. Thank you for joining us on tonight's show. Professor Ruhan Samarajiva, Chairman, ICTA and Chair, Learn Asia. Thank you for your presence. Mr. Kanishka Vitarna, Attorney at Law, joining us for the first time today, but certainly not the last, I hope. And finally, Kitmina Hevage, Research Officer, Institute of Policy Studies. Thank you, Kitmina. I'd also like to thank Charita Fernando and Naveen Majid for asking fantastic questions. Tonight's topic focused on the controversy which continues to surround free trade agreements in Sri Lanka. Specifically the one signed between the governments of Sri Lanka and Singapore, but also with a focus on the several FTAs in the pipeline. We focused on several key issues, including whether there are merits to the various concerns raised by certain sectors of society, specifically politicians, professionals, and of course, we considered the importance of free trade agreements in Sri Lanka's road towards progress, prosperity and economic development. On that note, we leave you. Have a great week ahead and thank you for your time. Good night.